Inclusion, please wait for some time. Please let me dispose of some of the matters thereafter. I will. Just when it was dismissed, 2020, 23, 6 May. Yes. Hearing, please wait for some time. Yes, call the list. Inclusion, please wait for some time. Okay. Maybe. Content. Yes, call the list. Yes. Okay. Petitioner is not here. What can be done? All right. None appears for the petitioner. First up, no accommodation has been sought for. First up, the petitioner was not represented. Petitioner was also not represented on 7th of November 2024 and on 11th of November 2024. So since the petitioner is not represented, the petition stands dismissed for default. First up, Mr. Ganguly, honored advocate, appears for this day. Next. The appeal petition is not interested to proceed to the Yes, next. This matter records were directed to be used. Mr. Only one thing I think, if I collect that Mr. Chandicharan Dev was appearing, he said that it may take some time to reach the records. It may not be at the inspection and documents have been furnished. All right, so where is Mr. Dev? Repeated occasions, it did not appear. All right. Among your juniors that been repeated 3 occasions, none were present. Was observed. All right, inform Mr. Ganguly, ask the junior to inform Mr. Ganguly. Records have come. That is, Mr. Park, that is in support of your submission that no 9 CB, effective 9 CB was served. For that, no, I only. Yes, but if the notice under section 41A was surviving as on the last day, that is 31st of March 1997, and it was due to expire after that, but on the date till it was surviving, what steps are to be taken for acquisition? What is the position of law?
If the notice are notification on 21st March 2027. But this ground what it means. If no notification is prescribed or not, then I understand. Therefore, I will not go into that.
So according to you, in case a proceeding, in case a notice under section 41A has been issued and the same was surviving as on 31st of March 1997, so it was due to expire sometimes after. So from the date of expiry of that notice, 3 years is the period of limitation.
Actually, from the present consistency is that award is the part in 3 years from the date of arbitration. If I take this notification on 1st of April 1997, not 21st March 1997. So, in the statute, they have said that 1998. The political subject and what are the subsection 2, section 7, which is clear from the data population of subsection 1. But if I say that 31st March 1997 so surviving, so that is the kind of date for the issue of the notice. So therefore, around 20,000 they have to under section 9. There I find about from the record that ICT was issued on sometime in the year 1998. The supplement petition they are filed and looking under section 19B, where it has been said the date of notice is 21st of August 1998.
Kindly come to section 7, capital. The collector shall make an award under subsection 2 of section 7 within a period of 3 years from the date of publication of notice in the official gazette under 41A, and if such award is not made within the period as aforesaid, the said notice shall lapse. Give me the dates once. In your case, 41A was
1994.
Give me the specific date.
December 1994.
Yes, I have noted. 19 December 1994 was 41A. So the award ought to have been passed within 18th of December
1997.
19th December 1997. So award was not passed. So on 19th of December 1997, 4-1A lapsed. Now,
that has been passed off in 1997. That was surviving.
that was surviving.
So it was incorporated 1949, section 9 was not amended.
Yes,
Subsequently, this has been amended.
yes,
Your person says that the moment this has been incorporated in the statute, meaning thereby, the state can issue 9CP notice at any contract. Because 941A was surviving.
4-1A was surviving. On 1st of April, it was surviving.
But that notice
When 9 was amended,
9 was amended on 1st of May 1997. With the retrospective.
1st of May 1997, Section 9
Section 9 was amended.
of Land Acquisition Act was amended, and with retrospective effect from 1st of April 1997. Yes. Now, 9CB says if there is valid notice of claim,
From 2nd May 1997.
with effect from 2nd May 1997, and amendment made on, so not with retrospective effect, so with prospective effect. So when the notice under section 4-1A was subsisting, section 9 was amended. So here what is their case? According to them, when 9CB was issued?
On 21st of August 1998.
21st of August 1998.
1998. And according to them, award declared award clear.
Award declared on so this so in this case 9CB was issued within the time when 4-1A was subsisting. There is no dispute with regard to that. An award was also passed within the time limit. Notice got issued.
According to the record, notice issued hearing done. But in 2009, they are saying that return back the award sheet, they return back the award since it has been expired and directed to revise the award. The condition the record at page that is at page 23 to 27 and on at page 23, the order dated 27th of March 2009. Page 23.
Page 23, yes.
26. This is the order dated 27th of March 2009.
27th of March 2009, yes.
I have marked that portion on the next page, page 24. Wherein it can be categorically admitted the lapses of the proceeding, and that was not the award, that is a draft award.
Thereafter, cell data was collected.
But that is the figure. What is for the 2009?
2009.
That was the second level. The other level, the level. Our operating bit, just for the data, this is for the 2050. But one was behind the order state. That as per new amendment, new amendment and amendment, they as per the cases.
Which page? Which page?
Page number 2001.
18th July.
2001.
Yes, 18th July.
2001.
Yes.
As per the new amendment and amendment, they
So where do you get that? 18th July is at page 22. Oh, as per, yes, yes, yes. Yes, there are two. Yes, as per the new, yes, I've got that.
the date as required to be assessed. So in 2003, in the booking of the collector, the date is to be assessed. Within that time, there was no award on that day. So award expired, 19 also expired. On the other moment, so this set of classes has not been awarded on the basis of section 933.
Nine 3B expired on 20th of August 2000.
In terms of the section given.
Yes, Mr. Rai. Anything more, Mr. Pan?
As I stated that now the award has been paid on the basis of the activity of the
So give me a minute. Mr. Pan, kindly come to 93B once. The collector shall also serve notice to the same effect on all such persons known or believed to be interested in any land or to be entitled to act for persons who are interested, the possession whereof has already been taken under section on requisition under section 3 of the said act, and notice for acquisition of such land has also been published under subsection 1A of section 4 of the said Act. So 9(3)B is the situation where 4(1)A has been published. Now, in your case, 4(1)A was published, but 4(1)A was valid or it lapsed on 19th of December 1997. 9(3)B was on a subsequent date. So what is the position whether in such a case when the notice under 4(1) there was no valid notice under 4(1)A as on 21st of August 1998, whether that was the question I framed on the earlier article, whether such a proceeding could be converted into an acquisition under 9(3)B or it has to be 9(3)A. That is my query. That was the question on for which I recalled the earlier order. What is your submission with regard to that? Whether this expression notice has been published means even if the notice has lapsed, then also by way of 9(3)B, can 4(1)A be revived? A lapsed notice under 4(1)A. Do you have any authority on this, Mr. Khan? Because there is no decision subject to correction by both of you. Then I have to decide this issue for the first time.
That the situation under the proceeding under the Act 2 has been for the partner of implementation of the position and
All right, without going to that far, in your case, if these records are gone, we need not go into those legal aspects. But this is a point which may arise in any other case also. Let us, where is Mr. K? Let us find out on facts. Because in this, if no award is passed, 9(3)B also goes, then everything goes, we need not go that far. Whether it could be revived under 9(3)B, we need not also go that far.
so this is the record handed over to me by the record shows that no even in 2009. And whatever document they have explained to the award, declaration of the award, and they have looked at that document also. This is the document.
Page, where? In the opposition. Yes. All right, last page. Yes.
That is the form 30. Form 30. Yes, sir.
Yes.
Now you want to decide everything, but without any indication, the date of the order. And moreover, nobody has been paid with the money of the appropriation has been done everything. Now this is the document. This is the return by the office of the collector, saying that because this thing because this is not valid.
This was returned.
This was the document. Now the prospect money Why and 2009 there was application for reassessment of the award, and this has been accounted in 2023.
It's the same case you have checked up. This number is same.
Because the document has been handled.
No, no. Have you checked up that maybe? Already, yes, Mr. Dev. Mr. Dev, do you have a copy of this? Mr. You have given inspection of the records to Mr. Pan. I think you have also given some relevant documents also. Do you have a copy of that? You can proceed on that. Because I only directed the production of original records so that they can have used. Now there is no dispute, you can proceed on that. He has made his submission. Now it's your turn. No, Mr. Dev, according to him, now in this case, notice under 41A was issued on 19th of December 1994. And according to you, 93B was issued on 1st of August 1998. But you have produced a document in the affidavit in opposition. Kindly come to the affidavit in opposition. Mr. Rai, kindly show him the document which page 15 of the affidavit in opposition. According to you, this is the award which was passed. So according to you, this was passed on 29th of March 2000. So it was award was passed within time. That was your submission. Now, from the documents which you have handed up to from the records, kindly come to page 23 onwards. Kindly come to more specifically page 24 onwards. Page 24, have you got page 24? Oh, Mr. Pan, do you have a copy of this? Is there a copy? Oh, you have only one copy? Yes, Mr. They take up this. Mr. Pan, you have prepared another photograph. Last few lines of that. Those papers were sent back. So award was not finalized. Award was not finalized. All papers, sale data, everything. Yes, now after that, what has been done? So on that day, 2000 no award was passed. All papers sent back. In 2009 also no final decision. So the notice should lapse. Mr. Dey, I can do one thing. If you want to go through your records, I am keeping it at 2 p.m. So go through your records. And Mr. Pan, make one more photocopy of it. You have only one copy. Heard Mr. Pan, learned advocate for the petition. Mr. Dey, learned additional government candidate, submits that pursuant to the earlier direction passed by this court and inspection of the records, pursuant to an order of the court, an opportunity was given to the learned advocate on record of the petitioner to inspect the records. Mr. Dey prays that this matter be taken up at 2 p.m. to enable him to produce the original records before this. এটা পরীক্ষা বা লেখা Call Mr. Ganguly, it has been dismissed in his presence. Order was passed in his presence. Bring him. Yes, call the next matter. Mr. Mojumdar has made his submission. Let Mr. Gupta make his submissions. If required, I will adjourn. Because Mr. Mojumdar has made his submissions. You are acquainted with the facts. Take note of Mr. Gupta's submission. If necessary, I will fix another date for Mr. Mojumdar. Yes, yes, Mr. Gupta. Mr. Gupta, give me a minute. Let me go through the. Yes. So according to you, the relevant date is the date of the written examination. Report in the form of an affidavit, no. Yes, affidavit in opposition, page 18. Admittedly, in your case, written test was prior to 8/5/2006. Yes. So there is no dispute with regard to that, that the old policy will be governed by the old policy. Yes, 16 or 17. All right, page 16. What is this promoted to? E5, because this is not very legible here. E5. Yes. All leftover, but who passed first class in these years, that is 91, 92, 93, you do not fall within that. Well left over. E5 with effect from 1st of March 1999. Then seniority will be refixed as per 1, 2, and 3. Yes, yes. One, two, and three. 1, 2, and 3 after this. In the following manner, 1, 2, and 3. This was restricted to these 91, 92, 93, and 94. After merger, this question of this refixation and removing the anomaly came up. Not merger, all subsidiaries. Central, yes. The date of certificate would be relevant. Yes. Sir, तो coordinator is this clause also refers to 91 to 94 or it's general? Yes, this is the writ petitioners. They were while they were working in E2. No, writ petitioners were in one. While working in E2 grade, they got promotion. They are covered by one. Yes. While working second class stream in E3, these are not the writ petitioners. Yes, I am at I. You are placing I. One second, yes. Yes, petitioner comes under I. Yes. So these are the private respondents. These are the private respondents. Yes. Suggested above means in one. I. Formula is suggested above. Above means I. Above II is I. Is I. Possibly 16. So subject to correction, it does not use the expression here before. It says above. But also the rules have to be interpreted because this deals with, because the previous page deals with a separate thing altogether. That is why I asked you whether this relates to 91 to 94. That is a separate thing to resolve or remove the anomaly. This is another with regard to what will happen in cases of employees passing NMs or FMCC at different grades. So this deals with this. So it says the seniority will as per above, because here it says how seniority will be in one, also seniority has been said. No, formula is, if you come to one again, those who pass such and such, we can skip that, should be placed in E3 first from the effective date of first class as mentioned. So this is the formula. Effective date of first class as mentioned under, that is the formula which is sought to be said here. Same formula, effective date of that. So this seniority will be as per the effective date of first class FMC. Subject to correction by you. This is what Supreme Court has said. Yes, so because there is no dispute with regard to that, that will fall to the earlier policy. There is no dispute with that. With regard to the starting point, your promotion will be covered by the old policy, not the new one. So only because the Honorable Supreme Court decision was only the issue which was before the Honorable Supreme Court was whether your promotion should be guided under the old rules or the new rules, not the seniority issue. These are the two different groups. Yes, two policies. Only it was restricted to that. No dispute with regard to that. Yes, yes, because there were others who got promotion as per the old policy. Now, at that relevant point of time, you were not considered as per the old promotional policy. You approach the court, ultimately the court held, Supreme Court held, no, you will also be governed by the old policy. So now you will get the benefit of the old promotional policy. But while doing that, whether or by way of refixing your promotion or seniority, by giving effect to the old policy, whether the seniority of others would have been affected. Yes. II. Yes. Private referrals were II. Where II, they were at the relevant point they passed that FMCC examination. So they will be promoted directly to E4, not to that horizontal but vertically as per the old policy. With immediate effect, that says immediate effect, but next seniority. Seniority or Mr. Gupta, since that clause II says as per the formula, whether it should be the date mentioned in the certificate. Mr. Gupta, there will be no difference. Even if we take the date of the written examination, subject to correction by you, or the certificate, because those who have appeared in the written examination earlier than you, their certificate date will be earlier. So I don't think this will create much of a difference. They were promoted much later. All right, let us, according to you, the date of holding the written examination, that should be the effective date. No, only for II. Only for II. Those who belong to II. So for that, what was your written examination date? Let us proceed on facts. 8/5, 8/5/2006. Eight five 2006. All right, let us. So, so let us take 8/5/2006. All right. So prior to that, so let us take it 7/5/2006. So you are promoted with effect from 7th of May 2006. So now, in the gradation list, where you will be placed in E4? E4? That will be relevant because they move vertically from E2 to E3. It's a 2 days. They move from E2 to E3 vertically by passing that exam earlier. There is no dispute. Now, from E3 to E4, they will move normally by way of normal promotion. So, what is the date of the writ petitioners being promoted to E4. If he became E4, E4 became E5. All right. We will come to that later. Let us. All right. So when they were E4, we can accept it as E5. Or you can, for the purpose of convenience, refer that as E4 because that will be much more. Okay, we can. So give me the date, that date, because petitioners they were promoted to 2013 to E4. So according to you, they were promoted prior to E4. Yes, your plan. Sorry. Yes, you appear for the company. Yes, it's the private respondent. No, they are not appearing. For the private respondent, not to. For the private respondent, according to you, were promoted to E4. Let us take that E4, not E5. Prior to the retreat. Madam, is this fact correct? What is according to you? So this is the factual issue. Yes, yes. There should not be any dispute on this. What is
my
the
lord.
date of your promotion order from E3 to A4?
My lord, the chart has been disclosed in the report itself.
Not the chart. Mr. Gupta says there is the promotion orders.
Those are in the writ petition.
Yes, in the writ petition. Because this file is bulky, that is why
Kindly take page 71.
of the writ petition.
Writ petition 71, a few more pages. Some consecutive pages. 71 onwards, 71 to 83. Below, kindly see 15th February 2010. The following assistant colliery managers placed in scale so and so, that is E4, presently posted in different subsidiary companies as indicated against it, are hereby promoted to the post of senior mining engineer in E5. E5
That should be read as E4, the earlier E4.
in brackets revised. Kindly note this.
Revised. So it should be, let us read as E4.
In the scale of Satan Church and
So-
posted in them.
So to E4, they were promoted in 15th of February 2010.
Some of them,
Not all of them.
not all of them.
The others are earlier or no, the only is
Others are later.
later.
2013.
So no one prior to 7th of May 2006.
All others are in 2013. And all consecutive documents, my lord, up to page 83.
All right. Mr. Gupta, you can make your submission because Mr. Mojumdar is not here. So kindly take note of this submission. Yes.
Therefore, my lord, they are not promoted in the same year because of this retrospective aspect. Because we are implementing a court order. The Supreme Court directs us to do it in a particular manner, namely, the first issue was apply 2000 policy. By apply 2000 policy, they are entitled automatically to vertical promotion.
Yes.
Now, what will be the consequence of the vertical promotion? Which will be the date? The date, my lord, is the pass, is the written test or year of passing. That is.
I think there will be not much of difference with regard to that.
With regard to that, they are
How much time? Maybe 2, 3, 4 months. Even if the date of the certificate is taken.
if the date of certificate was the basis, was made the basis, then we would be they would be governed by
Policy is there. But from which date your promotion may be affected,
because the policy.
Promotion is not to be effected from the date of written test. No, I am not contending
That is why.
I am not
So
contending
promotion will be effective with effect from the date of the certificate. But
from the date of-
you will be governed by the old policy since the selection process started earlier. There is no dispute with regard to that.
But
Mr.
the,
Mojumdar also
but,
did
but,
not
but
dispute
the seniority with effect from the date of passing.
date of passing.
Yes.
So
But the question is, if someone is promoted to a particular grade, his seniority needs to be considered as higher than those who did not get the promotion right. Suppose
yes,
somebody else gets promotion later on.
yes,
Join me.
because according to you,
Because they
from
got
E3 to E4, you are promoted, let us take in the year 2006. Let us keep over the mark.
into the 5th of February 2007.
All right, in the year 2007.
Yes.
So you are promoted to E4 in 2007,
Right.
and petitioners, not you, sorry, the private
I-
respondents were promoted in 2007, and the petitioners you have shown from the documents in 2010 and 2013. So subsequently, so you entered in grade E4 pre-revised
Yes.
earlier than the writ petitioners.
Exactly. That is the question. Because unless one is born in a cadre,
Yes. So you have
Uh,
shown that is the guiding principle for deciding who will be senior in that particular grade, born in that grade.
yes,
So from facts, according to you, these private respondents were born in grade E4 earlier than the petitioners.
Yes.
If that is so, they will be
they remain junior.
senior to the petitioners.
The respondents will be senior, as is now being. Earlier, they were senior in the lower grade.
Yes.
Why? Because
they passed FMCC.
no. Why? Because these category, according to court, they were deprived of a benefit due to them.
Because at
That
that
is the
point
logic.
of time, they moved vertically from E2 to E3.
Yes,
But you moved from E3 second class to E3 first class.
I remained in E3.
Remained in E3, pursuant to the Supreme Court, not you, the private respondents were moved to E4 vertically.
Yes.
So there, according to you, the petitioners moved to E4 after these private respondents.
Yes. Factually,
Factually.
the petitioners got promoted to E4, erstwhile E4, during 2010 to 2013.
Yes, so after that,
While by virtue of the court's interdiction, the respondents were earlier deprived and they were entitled to be promoted vertically much earlier with effect from the date of pass. Now, that way, their promotion was fixed from 2007. In 2007, my lord, if your lordship takes the trial court judgment, which went up to the Supreme Court, my lord, kindly take my affidavit in opposition.
your affidavit in opposition.
I'll place the division bench judgment also later. Kindly take the trial court judgment first. Starts at page 20.
Trial court judgment is page 20.
Kindly come to 35. Page 35, bottom.
In the present case.
Yes. In the present case, the petitioners appeared for the first class mine manager certificate examination and passed the same in December 2005. The office memorandum dated 12 June 2006 sought to destabilize them and by giving retrospective effect, virtually sought to extinguish the legitimate expectation of the petitioners. In my considered opinion, any change brought after commencement of the selection process cannot be given retrospective effect so as to bind.
So basically, the single bench also held the same thing. What the Supreme Court? Supreme Court.
One additional thing.
Written examination.
No, written examination is Supreme Court addition, but in the trial court there was one the last paragraph. The respondent authorities are hereby directed not to give effect
Yes.
to the memorandum dated 12 June 2006 to the lead petitioner so far as the claim of the present petitioner concerned. The said authorities are directed, kindly mark this, directed to promote the petitioners to E4 grade from E3 grade in the first class channel with effect from the date mentioned in the first class certificate by treating them at par with 2003, 4 and 5 batches forthwith. Why these 2, 3, 4 batches are mentioned here? Because in respect of batches past FMCs in 2003, 4 and 5.
Those were under the old rules.
All were under the old, these were under the old rules, first thing. Secondly, in their case, the promotion was given with effect from 5th of February 2005, 2003, 2004, 2005.
So with effect from a particular date of that year.
And in respect of this category, they passed in 2006 here, the respondents, private respondents in the present case. They passed in 2006, therefore for them, it was given 2007. Others were 3, 4, 4, 5, 6. 54 were given 4, 5, 6, 5th of February. And this group, the 2006 group was thus given 5 to 2007.
So parity was maintained. So according to you, yes. So this was in addition. So what would be the effective date from in respect of which they will be given promotion?
And this was never, my lord, turned down by.
So Mr. Gupta, so far as the private respondents are concerned, this should be, if this judgment is read as a whole, so their promotion as per the old rules from E3 to E4 has to be given with effect from 5th of February 2007.
Now, so far as lead petitioners are concerned,
they are 2010 to 13.
Totally different. Why? Because this situation never appeared, never happened in their case. They were rightfully promoted to E3.
They obtained that benefit at E2.
Yes.
At E2.
Yes.
So they moved to this grade.
Yes.
They moved to first class channel earlier,
Yes.
but by normal promotion, they were below.
Promotion was
They were below the private respondents. Anything more? Do you want to cite any decisions?
On only one. On a very simple proposition. Doesn't care. Just from your side. Amarjit Singh. No, this is 2010, volume 1, Supreme Court cases, page 417.
Yes.
Kindly
Paragraph
27.
27.
Lords. At page 425.
Yes.
The law permits promotion with retrospective effect only in exceptional circumstances when there has been some legal impediment in making the promotion, like an intervention by the court. An officer cannot be granted seniority prior to his birth in the cadre, adversely affecting the seniority of other officers who had been appointed prior to him. I am referring to this line in the context of E5 promotion, present E5 position. Therefore, when one officer comes to E5, his seniority comes from that date when he comes there, not, my lord, others who were senior in the earlier grade, but they didn't, my lord, get this promotion in 2007. Therefore, they
were not in that cadre in 2007. And those who were in 2007 in E4, their seniority, according to you, has not been affected.
No, certainly not. And there is no challenge also.
No one from that has come.
No.
Yes.
The latecomers to the regular stream. I read regular stream, I read E5. The latecomers to E5 cannot steal a march over the early arrivals.
So according to you, in the facts of this case, petitioners are latecomers.
Petitioners are latecomers.
Latecomers in respect of
E5.
if
Current.
revised E5.
Right. Possibly, my lord, this case may not require a remitting to the authority. Your lordships can decide it because it's on point of law straightway. No fact possibly, because on the last occasion, my lord, the court was contemplating whether this requires to be remanded to the authority for.
Yes, because if there is any factual dispute,
Yes.
now according to you, that is subject to Mr. Mojumdar's
Absolutely.
argument. According to you, there is no dispute because your promotion was with effect from 5th of February 2007.
Yes.
And the petitioners all were promoted
10:30.
from 10 to 13, so they were subsequently promoted. So if that is so, then, and if they can, then they have to show that they were in the pre-revised E4 prior to 5th of February 2007.
Then they are senior.
Then the question of readjustment or refixation of this seniority can arise.
Here, my lord, the private respondents are getting the benefit of the Supreme Court judgment because they straightway get 2000 policy benefit means vertical promotion.
Yes, because the issue was that. So whether the old policy, if old policy vertical, there was no other thing was decided, seniority and other things that was not said by the Supreme Court. So the question of affecting the others' rights as
That
per
didn't
that
come.
decision,
Didn't come
prima
up.
facie does not appear to be.
Didn't come up for consideration.
It has not said anything with regard to the
They are
seniority.
only contending about their own right.
Yes.
That would
And which rule
yes,
will apply in case of these persons?
2000 or 2006.
Yes.
My lord, courts in one voice, all the courts, single bench, division bench, and the Supreme Court held that 2000 policies to be applied, and which automatically means vertical promotion. Then from which date it is to be given?
And that is also not the challenge here, that the could not have been, because it has been
Already
upheld
settled.
up to the Supreme Court, that these private respondents could not have been given
Yes.
promotion as per the old policy.
No.
Those challenges
That
could
cannot
not
be
have been made. That has not also been.
Let Mr. Mojumdar react to my submission, my lord, on any date.
So this is the see, this is the basic thing. If this is decided, other from promotion to other grades will follow. That will automatically follow.
Exactly.
Once the seniority in a particular grade is fixed, where this dispute cropped up, thereafter the other things will follow according to that.
Other thing will
From E5 to E6, E6 to E7, so those will be according to
mere consequence.
consequential. And if this, if the Mojumdar's contention is to be accepted, that they were seniors, then everything has to be.
Again, that is also consequential. It depends on how the court holds. Whether the promotion of the private respondents to E4, erstwhile E4, from 5 to 2007 was valid or not.
Yes.
Or was in consonance with the judgment of the.
Mr. Gupta, in that chart, kindly show me from that chart that this was given. Mr. Mojumdar has given a chart from E2 to E3, E2 to E4.
It is there, chart.
That tallies with this. You have checked up.
I have checked up, but I have annexed the promotion orders themselves.
Yes. But that was a chart prepared by you.
But prepared by me.
And indicating the dates, my
These
lord.
are the actual orders.
All right.
My lord, only two things, if your lordship kindly allows me to submit, my lord, subject to Mr. Mojumdar submitting on the next date. My lord, my learned senior friend was contending regarding, my lord, promotion from E3 to E4 with effect from 5/2/2007 of the private respondents. My lord, the impugned order, here are two impugned orders. One of them is of 2000.
Impugned orders in this writ petition.
Lordship.
Yes.
11th February 2015, we were aggrieved by the order whereby, my lord, the refixation of seniority of private respondents in E5 was retrospectively given from 5/2/2007.
Yes. E5 means E4, the pre-revised E4.
Lordship.
E5 means pre-revised E4. Yes,
Hello.
that Mr. Gupta clarifies that is with regard to the last paragraph of the coordinate bench decision in the other matters. It says it is to be given as in 2003-4-5. Mr. Gupta submits that for 2003 batch, it was 5th of February 2004 and so on. So since these private respondents were in 2006, it was given with effect from 5/2/2007. That is Mr. Gupta's submission, if I have correctly understood his
My
submission.
lord, kindly comes to page 64 of the writ petition are the
Yes.
promotion orders
Yes.
from E3 to E4 of the writ petitioners.
Yes. Page.
Page 64. My lord, this is dated 29th March 2007. The following assistant colliery managers in E3 grade posted in different companies.
This is the 29th of March 2007. Yes.
Lordship, who passed first class mines manager certificate of competence in 2002 or thereafter while working in E2 grade and promoted horizontally, moved to their existing grade in first class channel from the effective date of first class, but superseded by those second class managers who passed first class MMCC after them while working in E3 grade, having rendered less service right from E2 grade as under manager compared to the former, but promoted to E4 grade by Coal India's order dated 18th October 2006 are hereby promoted to the post of senior mining engineer in E4 grade in the scale of such and such as per the provisions
Madam,
of.
give me a minute. Give me a minute.
My lord, the next page.
Yes.
Lordship.
So according to you, they were petitioners were promoted on 29th of March 2007.
No, my lord, kindly comes to the next page.
Next
The date
page.
of order, my lord, on the basis of which they were promoted is 18th October 2006. My lord, next page, the promotion of the above executives will be notionally effective from 18th October 2006.
This is the list. The petitioners fall within this list.
My lord, not all, my lord, only we could arrange.
Some fall within this list.
My lord, kindly give some words.
Yes, yes, maybe next page 66 also some. They are also 18th of October. So according to you, this petitioner's effective date of promotion to E4 is 18th of October 2006.
My lord, these orders are, my lord, after the judgment was implemented, my lord, it was not only for Rakesh Prasad, it was also implemented for other executives in E3 grade. My lord,
No,
this
the
is the
petitioners fall
consequence of,
within this list.
my lord,
There is another list at page 66 also. A list of 4 persons. Ajay Kumar is one of the petitioners.
No, my lord. My lord, I shall come back.
Mr. Gupta, which the promotion orders you are referring to was at which page?
71 to 83. I don't think, my lord, the names are tally. So I have not deeply checked it. On cursory glance, my lord, page 71, the lordship may keep a note of
These are the petitioners.
not all. Number
But
one.
some.
Number one.
Number
Petition number 3.
3.
The lordship kindly makes a note of it. Serial number 1 is writ petitioner 3. Number 3. Serial number 3 is writ petitioner 4.
So some of the writ petitioners are in that.
Many of them.
My lord, number from number 5
Many
to
of them.
And what is the
5, 6, 7.
page
or-
64 document, Mr. Gupta? What is page 64? Here also the same categories have been referred to.
I need to look into it whether this none of the petitioners come within this.
None of the,
None of the petitioners possibly
No,
name
but-
is there.
but if they fall within this group, because this category in respect of whom is the first paragraph.
Assistant
Different companies who passed in 2002 or thereafter while working in E2. This satisfies, the petitioner satisfies this, and promoted horizontally moved to their existing grade in first class channel from the effective
condition
date,
is totally different.
but superseded by those second class
Kindly
managers
see,
who
kindly-
passed.
Kindly see, and were horizontally moved.
Ooh,
Lordship, my lord,
Those are
promoted horizontally,
Yes.
not vertically.
my lord,
So
paragraph
this
8.
does not, this is because since they were horizontally, they were given
And 9 of the
not
writ
your
petition.
case.
My lord, this is pursuant
Paragraph?
to paragraph 8 of the writ petition.
8.
8.
Yes.
My lord, it refers to, my lord, some executives in E3 grade, namely Rakesh Prasad and others who were claiming promotion from E3 to E4 grade on the strength of their acquiring FMCC on a prior date than their counterparts, filed a writ petition in this honorable court, and the same was decided by a judgment and order dated 26 September 2006, wherein it was held that seniority cannot be broken at various stages of service career and that meritorious candidates acquiring FMCC on a prior date could not be superseded.
No.
My lord,
Yes, that
this
is-
effect, the judgment of this
But
effect was
Mr.
given to.
Gupta says, according to Mr. Gupta, if 71 is your promotion order, page 71, in respect of some, you have to show with respect to the others. What is the date? So prima facie from page 71, it shows that the date of your promotion is 15th of February 2010. So prima facie, you are junior to them in that grade.
After giving them retrospective effect of seniority.
Yes, that is the order. That is the
That
decision
is-
of this coordinate bench as affirmed up to the Supreme Court. But madam, you were given vertical promotion, you got that. There is no dispute with regard to that. Now, from that, your next promotion also you got according to the normal way. You have also not disputed that you ought to have been promoted to E4 on a prior date. That is not your challenge. Your challenge is that these private respondents could not have been placed above you since they passed the FMCC after you. The question is not that. Though they have passed FMCC after you, but by virtue of that order, they went to E4 at a point of time when you were in E3 and you were promoted to E4 by way of normal promotion after them.
Then
So
my lord,
in E4 you were junior to them.
lordship in
That is
E5.
the submission of
My
Mr.
lord, the
Gupta.
gradation list, my lord, which I have annexed starts from page 88. Kindly comes to page 90. This is a
Of the
gradation,
repetition.
of the gradation list
Yes.
of E5, whereby, my lord, the petitioners, my lord, appear to be in higher position than the private respondents.
No, that was when. This was
2nd February 2015 gradation list of E5,
but
page 88.
when this was refixed, Mr. Gupta?
It was
This refixation as per the Supreme Court's decision must be
Refixation,
after
my
this date.
15.
11th
Must be
February,
after this date.
February
Must be
2015.
after this date.
My lord, 2nd February and 11th February. 2nd February gradation list, we are shown higher, in
Yes.
higher position. 11th February
So
2015.
11 February, what happened? Because they moved horizontally. That is why they were in a lower grade. But pursuant to this order, they were directed to move vertically. So this was prior to giving effect of the Supreme Court judgment subject to correction by both of you. This gradation list at page 90.
Right.
Prior to giving effect of the Supreme Court's judgment.
The date of the Supreme Court order is 18/11/2014,
Yes.
but it was not implemented on this was.
So when they finally took the decision, it has to be after this gradation list. So they were below because the private respondents at that point of time, they were directed to be moved horizontally, not vertically. That is the dispute. When can Mr. Mojumdar give his reply?
My lord, next week any day, my lord, except Monday and Wednesday.
Next week.
Except Monday.
Except Monday.
Monday and Wednesday.
I'm fixing a date. If there is any problem,
Lordship.
also let a chart be prepared with regard to, I think there cannot be any dispute with regard to this, that this date of promotions, when they were given to, as we have said, and the petitioners respective date of promotions.
My lord, may I show up another thing, my lord? The chart which has been disclosed, my lord, giving all the dates of, my lord, promotion from E3 to E4.
Yes.
My lord, that also will show that the petitioners, for example, petitioner number 1, my lord, page 24 of the report.
Of the report.
Lordship. And also kindly considers page 33. My lord, may I only compare one petitioner and one private respondent?
Page 24, yes.
Madhusudan Singh is petitioner number 1.
Madhusudan Singh, yes.
Lordship kindly considers, my lord, the second last column, E2 to E2, 28 February 2002. E3
Yes.
to E4, 13th August 2004. E4 to E5, 15th February 2010. My lord, kindly comes to page 33 now.
15th February 2010 is not page 71.
Yes.
Page 33, serial number
This is,
31.
this supports the case of Mr. Gupta. This kindly come to page 24.
Gotcha.
This is the revised grade. So now read everything. Read E3 as E2, E4 as E3, pre-revised.
My lord.
Because you passed FMCC on 13th of August 2004. At that point of time, you were in E2. On 13th of August, you were promoted vertically to E3. So E2 to E3 is 13th of August. Read this E3, E4 as E2 and E3 because these are the revised. So E2 to E3 is 13th of August, E3 to E4 on 15th of February. So you are junior because that tallies with that promotion list, order of promotion as Mr. Gupta has placed. And the private respondents moved to E4 pre-revised in 2007. So they are
Page
Senior.
33, my lord, this is also in accordance with the judgment which has been, my lord, page 31 will show this list has been prepared as per Honorable Supreme Court judgment. Page
But
31,
in the meantime, there has been a revision in the grade that is causing problem.
but my lord, E4 they
read
have
this.
shown is as,
Read in this chart, read E3 as E2, E4 as E3, pre-revised. Then everything will be clear.
then my lord, from E3 to E4 they have shown that 7th of June 2006.
Which page?
Page 33.
33.
Yes. My lord, this is as per, my lord, Supreme Court's judgment.
Yes.
E3 to E4, 7th June 2006. Serial number
Page 33
31.
you said.
33.
Yes, 33 is for whom?
Serial number 31 is private
Yes, yes.
respondent 1.
E2 to
E2 to E2, 6th March 2002, which is after me. E3 to E4, 7 June 2006, which is after me. Because, my lord, this
no,
petitioner
madam,
got...
this is clear. Kindly see. Kindly read. The problem is pre-revised and revised.
My lord,
That
what
is
about
the
residuary
kindly read
period?
this chart. One step back. All the grades in respect of all. This look, 7th of June 2006 is FMCC. This is the private respondent. He is the private respondent. He passed on 7th of June 2006. Look, 7th of June to 5th of, so, but his promotion from E3 to E4, read E4 to E5 as E3 to E4 on 5th of February 2007, as Mr. Gupta has submitted. And yours is in 2010.
But my lord, in between there is no residency period that has also to be considered. My lord, there has to be a residuary period in between the two promotion that is then effective 2006 and 2007.
Consider this.
My lord, my lord.
Consider this and come back, because the chart, the problem is in the meantime grades have been revised. That is causing problem. Read one step back or one step forward. You will have to consider that you got FMCC while in E3, then you have to read that from E3 to E4 to E4 to E5. Then the chart will tell. Either way, because you have to put both things on a same platform. Then you can compare. Ashun. Mr. Gupta, Lanet Senior Counsel, concludes his argument. Stop. An accommodation has been paid for. Acha, I do liquid. Ms. Dotto, Lanet Advocate, commences her argument in reply. Stop. She, however, prays for an accommodation to assist this court on the next occasion with regard to the points raised by Mr. Gupta in course of his submission. Stop. As prayed for by the learned advocate for the petitioner, list this matter in the next week under the same heading.
But Tuesday, my lord.
Yes, there is any difficulty fixing a date, madam, is a problem, or let it appear. In case it is taken up on Tuesday, Mr. Mojumdar will be available. And you can do one thing, you can also prepare a short note on this, clarifying this, because now it has boiled down to a...
And then kindly keeps it on Tuesday, my lord.
If required, you are getting a long weekend.
It will not be on Monday.
For what? You have concluded.
If your lordship needs my presence, I don't. Otherwise, your Monday may not many matters are fixed.
May not be taken up on Monday. I'm fixing it in the next week. If both of you have problem, I will consider that. Certainly, it will be better if both of you remain present so that this can be clarified. In your presence, Mr. Mojumdar can clarify. This is a factual issue. Now, it has boiled down. Yes,
On my request, Mr. Ganguly came to Lordship's Court at 11:30.
all
when
right,
This matter was going on.
all right, recalled, item number 4. 4 recalled, recall করে।
What?
Yes,
Item number 4,
4টা recall করে দিন ওটা। Yes,
recalled.
yes, next. Item number? No, 4th তো এ হয়েছে other side. Where is Mr. Ganguly?
He came at 11:30, but he is in court number 2.
All,
On my
পাঁচশো ভাগ
request,
করে রেখে দিন, recall করে 500 ভাগ করে দিন। Yes. Dismissal orderটা বারণ করবেন। Yes. Yes, call the next matter.
No, 8 not 14. 14.
My lord, I beg to appear on behalf of the petitioner. On the last occasion when this matter was taken up, my lord was kind enough to again direct us to serve a notice upon the alleged contemner mentioning that the matter to be listed today and for also to file the affidavit of service of 5th November as well as 4th November. May I file the affidavit of service?
It has been served.
It has been
You are
served.
appearing.
I'm appearing for the Shipping Corporation of India, my lord. My lord, yesterday only from our client, we have received the brief. Not yet, my lord, have filed the Wakalatnama. Today, my lord, we will file the Wakalatnama, my lord.
How many contemners are there?
One.
One. So you are, yes,
Kindly give me, my lord, 7 days week, 7 days time, my lord. I'll come and appear with the. I'll be briefed in the matter properly, my lord, to appear and represent the client, my lord. Kindly, my lord, keep it on any day except Monday and Tuesday next week, my lord.
what was the direction passed?
My lord, kindly take note of page 20. It is an order dated 21st March 2023. Page 20, my lord was kind enough to direct
Page 20.
20. 20, my lord, third paragraph onwards.
Yes,
The learned advocate representing the respondent number such and such submits that the money suit such and such is pending and also submits that the petition is not entitled to the said amount. Since no final decision has been taken by the Shipping Corporation of India,
only to take a decision.
that's it. But after giving an opportunity of hearing, I
Yes.
must point out, I must
Why this has not been done? It was passed on
21st March 2023.
21st of March 2023.
Proper instruction, my lord, we did not get, my lord. Honestly speaking, my lord,
And
yesterday.
I must also point out, my lord, I have indicated that 23rd March by a forwarding letter dated 23rd March, this was served upon the alleged contemner, but I could not find that that document has been misplaced. I've indicated that also. So, my lord,
All right, since she
that
has now
will be my
appeared.
fault. That is my fault, that part.
All right.
যা চলে যা। আমি যা-
Learned advocate for the alleged contemner
My lord, may I take my lord's leave?
prays for a week's time to take instructions in this matter. To stop, list this matter after a week under the same heading as prayed for by the learned advocate for the alleged contemner. Affidavit is
The department.
to file in the department. কি বললাম? The affidavit of service filed in court today is taken on record. The learned advocate for the alleged contemner will be at liberty to file the Vakalatnama in course of this day in the department. Yes. Next.
84. 84. 84.
None appears for the petitioner. At the time of call, no accommodation has been sought for either. For the ends of justice. 84.
No, 85.
The hearing of the matter stands adjourned for the day. Next.
My lord, in this matter, my lord, it is stated,
85.
my lord, state advocate counselor, not performing, ma'am. I am paying for 1 week time for.
You are for the petitioner of the state.
No, my lord, I am appearing for petitioner, my lord. But my learned senior Polai Bhattacharya for this matter, my lord. I'm paying for service, my lord. 1 week time, my lord.
What service?
State for state.
My lord, the affidavit has already been exchanged, my lord. We have filed the affidavit in opposition.
My lord, kindly fix it at 2 p.m., my lord. Kindly fix, my lord, at 2 p.m.
The matter was heard. There is no interim order in the matter, my lord. Affidavits has been exchanged, my lord.
My lord, kindly fix
All right, 2 p.m.
My lord, can it be not today, my lord?
Why? Yes, 2 p.m. Next.
Yes, my lord.
Call the next matter.
86.
None appears for the petitioner at the time of call. No accommodation sought for either. For the ends of justice, the hearing of the matter stands adjourned for the day. Next.
87.
None appears for the petitioner at the time of call. No accommodation is sought for either. However, for the ends of justice, the hearing of the matter stands adjourned for the day. Next.
88.
My lord, I'm on behalf of the petitioners, my lord. This was a matter of 95 scheme under the EPF Act.
The matter of
95 scheme, my lord, which was under challenge before the Honorable Supreme Court and finally got disposed of in 2004. Now, in this matter, there were certain documents which the PF authorities could not produce. Your lordship on more than one occasion.
Order take account. Just leave me alone. Leave me alone.
My lord, I am led by Mr. Sudarsata Banerjee.
yes, Mr. Banerjee.
Get nervous every time I hear that. I get nervous when I hear that I'm being led. Too much responsibility.
Yes.
But you kindly have a look at your lordship last order. I'll just give a brief background.
Order dated.
Last order. Just give me 30 seconds. I'll just order to the last order. This was a 7A proceeding. After an order was passed, we had indicated that certain persons who were working with us had already retired. There was a switchover from the family pension scheme and provident fund, and the Supreme Court judgment came. By then, about 84 people had retired. Remaining everybody we've paid, that is an undisputed position. With regard to people who have retired, we've put out an advertisement also. No one's come forward. They've taken their family pension and gone. Now, whether in that conduit it's payable, not payable, that's a separate issue. 7A proceeding on an imaginary basis, they come and indicate that these persons have not received, you have taken the money, therefore you are liable to pay this amount. I show a judgment before this court saying 7A can't be a roving inquiry. If you say that certain persons who are entitled to have not gotten the benefit, then it is for you to come and show who are these people who are entitled to. You can't just say random figures you can't give, primarily in view of the facts here, where the authority itself has given a certificate saying everything is payable. Indeed, that.
Show me the order passed under section 7.
Yes, yes. It
page 21.
2021. I'm
Page
grateful.
21.
Page 21.
Yes. Yes.
21. period, just kindly have a look at, my lord, and then disregards everything, my lord, just turns over to 22.
Yes. So according to them, this sum is due.
No,
from
no,
the
20
establishments.
it's closed. I have 22 at the top, at page 22.
Yes.
I have verified the document submitted by Woodlands, especially the certificate given by so and so. I find that was due from the establishment under the scheme towards principal dues, which has been paid by the establishment on different dates. Hence, the matter is concluded as closed. It is clarified the establishment is also required to transfer cumulative interest earned from trust. This is another aspect of it. This is not in dispute here. That's not a part of the 7A order also.
Yes. So the matter is closed.
Matter is closed. Then again, 23, kindly see. At the top left-hand column, at the top left-hand, your lordship will find 16 February 2006. There's a public notice which, for the benefit of this honorable court, we've highlighted.
Yes.
Intimate that all ex-casual employees who have not withdrawn their PF dues are requested to collect the same within
This
15
is on your
days.
part.
This is on my part. Now turns over to 24. This is what is assailed. The order in this is assailed.
No, this is a summons to appear.
This is the summons to appear. No, this is
Any order has been passed.
Yes, this is the order we've challenged here.
No, this is the summons. What is
This
the
is the
order?
summons for 7A.
Yes.
At page 42.
42 is the order.
42 is the impugned order. No, no. Order it at page 29. No. This is the order.
Yes. What is your submission on this?
Well, this kindly turns over to 43.
Yes.
On perusal of submission of the employer and the department, and after applying my mind to the evidence on record, it is evident that the employer failed to extend membership under 95 to, please mark this, my lord, certain employees varying for 126 for the month from April 2002. This is covered under the previous order, to 151 for the month of May 2005. So this 126 to 151, which is not acceptable as per so and so. Hence, on the basis of the evidence available, I determine an amount of rupees so and so payable against the establishment.
Yes.
This is covered by the previous order because that order is of 2004. Page 29.
29 or 21?
Page 21, sorry.
For the period 16/11/1995
till date. Onwards.
For the periods
onwards
is 7th of October 2004.
2004.
So according to you, up to 2004 it was closed.
Everything was closed. Well, not according to us.
But this says up to May of 2005. There may be some period.
Well, kindly, the 41, your lordship has seen that we have indicated that whoever has not received, please come and take.
Yes.
No one has come forward. There is absolutely no basis for them to arrive at this conclusion. And one more document, Lord, I'll just indicate that we had shown even on the last occasion, and therefore your lordship had asked them to produce particulars by the last order.
Yes.
But I'll just indicate that, Lord. Kindly give
This is the assessment made. The next document is the tabular chart.
Yes.
So thereafter, review application was filed.
Lord, if your lordship looks at 35, in fact, 31 onwards.
31.
31 onwards.
Yes.
Total pension of casual staff which has been paid to them at the time of the settlement instead of depositing to RTPFS this is a list. And if your lordship turns over to 40,
Yes.
236 at the left hand corner, your lordship will find a recording.
236 settlement
taken, 48 pension deposited, 284. Turns over.
This is your recording.
This is what the authorities have relied on.
Yes.
Then I make an advertisement as on February 2006. So there is absolutely no basis on which they come forward and say that there is an assessment, this has come outside. Which, because I'll tell you, notun chirita dekhao na. Just the frivolity of this proceeding. Last order tak bar ko na says Yes, kindly have a look at your lordship's order of 30th of November 2023. 30th of November 2023. 30th November to dekho. Well, there your lordship would have directed, I don't have it right now with me.
Yes.
Your lordship would have directed them to provide particulars.
Basis for determination under section 7.
Yes. This instruction they don't take. 30th November, your lordship will kindly, yes, my lord.
Yes.
There is a writ petition, therefore requires some time to consult the records as to appreciate the price. This court, the basis on the determination of 7A, because of the judgment that we had indicated to this honorable court. Then next order, your lordship will find of 14 December, he takes time. Yeah. Now, what does Woodlands do? I mean, what does the authority do? Please have a look at this order, my lord. Ita na? Please have a look at this one. This is post your lordship's order that you provide particulars on what you've made the assessment. They write to me. In compliance with the office direction letter so and so, it is requested to provide the detailed statements. Your lordship will find the reference to the writ petition at top.
Yes.
No, sorry. Detailed statement chart in respect of all 126 employees with supporting documents for the period from so and so to so and so. The amount assessed. On this basis itself, the 7A should go. Your lordship directs them to produce the basis of the determination, which is why Mr. Prasad doesn't appear anymore.
Yes.
Your lordship, Mr. Prasad is appearing in another court, your lordship. Kindly give me an opportunity of time. He is busy in another court, your lordship. Kindly give opportunity of time.
2 p.m. Ask him to come at 2 p.m.
2 p.m. Judgment. Look, instead of 2 p.m., if you could come back on any other day, my lord, if you could, I know it will be difficult for your lordship to fix it.
Difficult. You have made your submission.
No, I'll have to show two judgments, my lord.
Yes, the judge-
Mr. Supratik Ray is there with me. He's gone to the hospital today. I'll be in some difficulty at 2 o'clock.
Uh, no, you can. You have the judgments with you.
No, my lord, I'm not sure I do. He's the one who has it. We had taken it out to show it to your lordship. On that basis, we had made the arguments also.
All right.
Just on the point that 7A determination can't be such a roving inquiry, you will have to show particulars on the basis of which you made an assessment.
Ashwin. Heard Mr. Banerjee, learned advocate, appearing, learned advocate for the petitioner. So an accommodation has been sought for in the ground of Mr. Prasad, learned advocate, appearing for the Provident Fund Authority. List this matter in the next week under the same heading. Yes, next.
Grateful.
Before a later. Yes, call the next matter.
89.
Yes, 89.
My victim for the respondent.
You are for the?
Respondent.
Yes.
Petitioner is died. Petitioner.
My filing affidavit in reply.
Petitioner দিয়ে দিয়েছো?
My lord, this is an old matter. From my file, I can see that affidavit in opposition has been filed. It's prepared. I don't know whether it was filed or not.
Just hard upon me, my lord, I filed reply.
Do you have a copy of the affidavit in reply?
I have reply copy. I don't have, my lord. And
No, opposition. Do you have a copy of the affidavit in opposition?
opposition office copy I have.
Yes. Yes. What is this matter?
The petitioner before my lord was constable in the CI, sir. Yeah. My lord, a charge sheet was issued to him.
Yes.
My lord, allegation also clarified at page 22. Allegation also find at page 22 of the petition. Allegation level.
What is the allegation?
Allegation, my lord, that an act prejudicial in good order of discipline of the force in that Constable Raja Kali of management camp was detailed in sea ship duty from Damparia North Side patrolling duty Rajmal camp. During his duty was theft of 350 liters of diesel was occurred from crane. This is the, my lord, allegation.
Yes.
My lord, I shall argue, my lord, that he was not alone. A few more personnel are there. His name has been given. I have given. But only he has been discriminated with others. He has been taken for giving the penalty. Others, nothing was done with the others. Second, my lord.
Yes. Show me the order. Show me the order of the disciplinary authority.
My lord, that is at penalty made portion page 40. My starts from 41 or penalty made portion is page 45. My lord.
Page 45. 5.
Thereafter, my lord, he prayed for documents. He wanted to prepare a next page on 46.
Yes.
He prayed for certain documents that is given for preparing appeal.
So after the disciplinary authority's order, you prayed for some documents.
Some documents, my lord, for preparing appeal.
That was rejected.
That was rejected, my lord. Then, my lord, he.
Now, what did the appellate authority do?
Appellate authority rejected. He prayed
Where
And
is the order?
then my lord, then my lord, he issued a show cause notice for suo motu review. That is my lord, page 49 comes first.
Page?
49, my lord.
Who issued a notice first?
Deputy Appellate Authority, my lord.
Under Rule 54.
49.
I shall argue, my lord, he is not at all authorized to issue this notice or take action.
So from reduction of pay to dismissal,
My lord.
removed from service.
Removed from service.
Yes.
My lord, thereafter, my lord, next page can come next page. What the disciplinary authority states, my lord, he paid for certain time for filing appeal. I was permitted to file appeal. Can next page
Appeal
50.
against this order. Appeal against the appellate authority's
No, no,
order.
disciplinary authority's order, my lord.
No,
That
against-
was kept pending with the disciplinary authority, my prayer. And after the so cause notice was issued, he permitted me to file the appeal. Can you see next page?
No, how can that be? If the order is reviewed by the appellate authority.
Not reviewed. That is notice. So notice to review suo motu.
What happened after that?
Thereafter, my lord,
You replied to the show cause notice.
he preferred an appeal. He preferred an appeal
Against?
against the disciplinary authority's order.
Oh, but you did not take steps against this review.
I'm coming, my lord. Can you press 52 is the appeal.
Yes,
Page-
you preferred an appeal against the disciplinary authority's order. Thereafter,
Page 52 is page 52, my lord. They are coming, my lord.
50?
My lord. Page
Page-
52, it starts from page 52 appeal.
Yes, yes. Thereafter, what happened?
I'm coming, man, coming. Kindly give me the. No. Huh? No.
What did the disciplinary authority do?
My lord, I'm coming, my lord. Coming. Mark it. Here is the page, my lord.
But the appellate authority on that suo motu review has passed an order
My lord, by that time, not
at page 84,
my lord. Thereafter, my lord,
at page 86.
my lord. That order suo motu review.
Yes. So removal from service that was passed by the appellate authority.
By the suo motu review.
Yes.
Whether, my lord, he is at all entitled to pass the order on suo motu review. Does the rule permits it?
Show me that
My
the rule
lord,
does not
my-
permit.
My lord, my lord.
And what happened to the appeal before the disciplinary authority? What happened?
Pending.
Pending. That has lost its force after the suo motu review.
My lord. I don't know how his permission was given to file.
What permission?
To file appeal? There are page I have shown, my lord. Kindly.
Did you prefer any appeal against this appellate authority's order?
My lord,
What is the order at page 110?
from 88, my lord, he submitted an appeal. He submitted, preferred an appeal,
So from the order of review,
my lord. This is the same order, appeal, rejected.
so now you are challenging this 26th of December 2008.
I'm challenging the,
So before the Inspector General, did you take this point that there was no provision for review?
my lord.
How the appellate authority has decided that?
My lord, they simply rejected on the basis of paragraph wise
Show me
comment.
the finding on that. Show me the finding under clause 7.
My lord, come to page 112. Page 112, Roman 7. My lord, got it?
Give me a minute. Give me the rules.
My lord, I'm giving you.
CISF rules
My lord,
2001.
my lord. Oh, my lord, please go. Can you come to page rule 52, my lord? First.
Yes.
My lord, appeal come to page 45, my lord. 46. Appeal against order imposing penalties. My lord, so rule 46, my lord. I'm showing appellate authority's power, my lord. It starts from page rule 46 to rule 52.
No, where is the provision for review?
I'll come, my lord. Can you see the appellate authority's done this? Can you see the appellate authority's power, whether he can do or not? I'll come.
Yes, appellate authority's power.
Rule 46.
46, yes.
Any order against file. 47. Period of limitation appeal.
Yes.
Rule 48. Forms and contents of appeal. 49. Submissions appeal. 50. Withholding appeal. 51. Transmission. 52. Consideration appeal. 53. Implementation appeal. Then my lord, power of appellate authority goes. He has nothing to do. Then can come to rule 54. Review.
Give me a minute.
কেন নষ্ট করছেন জয় সাহেব এটা কি মাথা খারাপ গ্রাম বিশ্বাস করার জন্য এটা জয় সাহেবকে দেবো আমি তুই পড়ছেন পড়ে এটা ভালো দেখুন আর্থ আছে সেটা দেখুন এখন ওই সময় আমরা দেখার সময় সারাদিন বসে দেখতে পারেন
Yes, which rule you are placing?
Now, my lord, I've shown up to 50 through my lord, appellate authority can sue. My lord, from 46 to 52, power of the appellate authority. 46 to 52.
46 to 52?
Power of the appellate authority.
Yes.
Appellate, now we'll come to page 54.
Yes.
Under which the appellate authority exercises power. My lord, any authority superior to the authority making the order. This is my lord appellate order.
The power of revision, not the power of appeal.
No,
54 is power of revision.
That's what I'm telling my lord.
Yes.
Against the appellate order only he can exercise the power, not against the disciplinary authority's power.
Yes.
Appellate authority's power is confined to rule 46 to 53.
Yes.
Then my lord, it has to be done by superior authority.
Yes.
Then my lord, appellate authority cannot do it.
Yes.
For more clearance, can come to Act Section 9 of the Act, my lord.
Section
9 of the Act.
Yes.
9(2)(a), my lord. Well, any enrollment members who are being agreed by an order passed in appeal under section 1 may, within a period of 6 months from the date on which the contempt, prepare a revision petition against the order to such authorized member. Well, against the appeal, revision order. Next, 9(2)(b). The authority has been prescribed for the purpose of subsection or revision petition preferred and given another board, suo motu or call for the prescribed period, a record. My lord, there is 2(b). This cannot, nowhere there is appellate authority. Revision application and revision suo motu either on preference to a petition by 2 more. That is against the appellate order.
All right. Come at 2 p.m.
My lord. My lord.
Before your lordship rises, my application WPA 12625 of 2019. Your lordship, by an order dated September.
Come at 2 p.m. Yes, yes.
Item number 1 for judgment.
One contempt of application, my lord.
No mentioning now. Yes.
My lord, may I be permitted to mention the
No mentioning now. Mentioning was made at 10:30.
This code is supposed to see Friday at 2 p.m.
সকালে সকালে বসেছে না জেনে দুটোর সময় এসছে
Yes.
লিখা আছে
I'm for the state respondent in item number 1.
In view of the reasons as aforesaid, the writ petition stands disposed of with the following orders and directions. The collector, North 24 Parganas, being the third respondent, shall take a decision either to acquire the balance portion of the requisition land measuring about 2.12 acres or to release the same from requisition by passing a reasoned order which shall be communicated to the petitioner within a period of 3 weeks from the date of receipt of a server copy of this order. In the event the state government decides to release the said property from requisition, possession of such land should be delivered to the petitioner or the person entitled to possession of such land not later than 2 weeks from the date of passing the reasoned order as indicated in paragraph A herein before. Upon release of the said land from requisition, the collector shall determine the compensation to be paid to the person interested in respect of the said land from the date of requisition till delivery of possession, and payment should be made to such persons within a period of 6 weeks from the date of passing the order of release of the land from requisition. If the collector decides to acquire the said land, appropriate steps in that regard should be initiated in accordance with law immediately after passing the order as indicated in paragraph A herein before, and the entire proceeding shall be concluded and compensation be paid to the person interested in respect of the said land within a period of 4 months from the date of passing the order as indicated in paragraph A herein before. No order has to come.
নামটা দিয়ে দাও। নামটা দেওয়া আছে পড়া মাস অফ লাইফ
Yes.
Item
All the
number
2
6.
matters.
My lord, I filed this that
Yes.
I have that my I have seen the order sheet, and order sheet, my lord, damage all the
Damage?
damage my case. What I stated before your lordship on the previous occasion, and your lordship passed the order. And that the order sheet can be wait, so my lord, I cannot do. Your lordship can pass the order according to.
Now,
According
because that was not the award as it appears from
Yes,
this.
my lord, by the order sheet, that is, my lord,
But
totally.
Mr. They only one thing, that is one way. But the officer affirming the affidavit, they should have been more cautious.
I know, my lord, only for that reason. my lord.
Because
I have seen on, my lord, on seeing these, my lord, I am very astonished that how one,
if
yes, my lord,
the earlier order
yes, my lord,
was not recalled and this direction, this would not have come out.
yes, my lord.
It struck me after passing the order at the time of signing that this is the law point involved for which I directed production of the records.
Yes, my lord.
Your officers should be.
Yes, my lord, I told him, I told them, my lord, to, that is why you damaged all the things, my lord. And that was not disclosed in the previous occasion, my lord. That is very, I am sorry to submit before your lordship. My lord, the record says, my lord, record says come, my lord, and that is according to your lordship.
Records,
No, my lord,
I'm
I am
recording
only
because
as-
this is the
as-
copy, Mr.
as
Pan
there
is also not disputing
Yes, my lord.
anything from
Yes.
that.
As there is an order, my lord, only for that reason I mentioned that matter. And I took time on the first occasion now. So your lordship can pass the order according to.
Yes.
না না এইটার উপর বেস করেই তো সবকিছু করেছে।
So in the original order, it was recorded that the award was declared on 29th of March.
Yes, ma'am.
That did not happen. So 9(3)(b), would 9(3)(b) stood lapsed.
Yes. Because my lord, that question, I don't want to argue on this matter, whether that can be issued or not. I will not.
Not necessary.
I will not,
Not necessary because
because of the
because
subsequent.
of the facts of this case.
Yes,
If that award was passed, then that
Yes.
point
That
would have.
point-
yes, yes.
So my lord, I may not want to go into that merit of the case.
বুঝবে ফট করে ধরবে আমাকে
Mr. Pan, kindly come to 11A.
Hello. Yes.
11A states that the collector shall pass an award under section 11 within a period of 2 years from the date of publication of the declaration. If no award is made within that period, the entire proceedings for the acquisition of the land shall lapse.
Yes.
Then proviso is that provided in case where the declaration has been published before such and such, this will be the time limit. After the proviso, the amendment
Yes.
in respect of the acquisition of the land referred to in subsection 3A and subsection 3B of section 9, the award shall be made within a period of 2 years from the date of issue of the public notice under section 9. But the subsequent thing, if not done, proceedings with lapse is not there.
No, my lord, can
What is the effect of
My lord,
this?
my lord, can I see? My lord, this should be read. This amendment is provided further. So this proviso should be read with the main enactment. Main enactment says that the collector shall make an award under section 11 with a period of 2 years from the date of the publication of the declaration. And if no award is made within that period, the entire proceeding for the land.
So according to you, only the period will change in respect of this.
My lord.
Other things remaining
This
same.
is the same.
Mr. De, do you want to make any submission on this?
At the period, my lord, that is a similar period is there, my lord, so I
All
may
right.
not want to.
Ashun. Pursuant to the earlier order dated 12th of September 2024, Mr. De Lanet, additional government pleader, produces the Mr. De, the original records are here.
Yes, my lord.
I've produced the original records. Stop. এটা না এইটার পরে না লেটার বলে অর্ডার করবে না ঠিক আছে Stop. Paragraph. In the affidavit in opposition filed by the respondent numbers 1 to 5, it has been stated that the award was declared on 29th of March 2000. Full stop. The Photocopy of the relevant documents from the original records have been filed by Mr. De Learned Advocate in course of the hearing of this writ petition. Full stop. A copy of such have also been supplied to Mr. Pan in advance. Full stop. Mr. Pan, learned advocate appearing for the petitioner, draws the attention of the court to the order dated 18th of July 2001, wherein it has been recorded that as per new LA, L full stop A within bracket amendment, Act 1999, rate per acre is required to be assessed. Full stop. He further draws the attention of the court to Mr. Pan, page 22.
Page 23, 24.
Yes, 23. What is the date of that? Oh,
Page
27th of March 2009.
Page 23, my lord, I'll tell your lordship.
No, the order which you placed at page 24,
No,
the order date is
27th of March, 2009.
ঠিক আছে, কি বললাম? Mr. Quote to the order dated 27th of March 2009. In support of his contention that the award along with all ancillary papers were returned by the concerned department by memo dated 9/5/2000 as the period of award has expired, for which recasting of award was necessary. First up, paragraph. Mr. De Learned Advocate appearing for the state does not dispute the recording made in the order dated 27th of March 2009. Thereafter, no order was passed, no further order was passed. Mr. De, no further order was passed after 27th of March.
Yes, but there is an order of 1st of October 2009.
1st of October 2009.
That is page 26.
Page 26.
Yes. But
the surveyor was asked to collect the sale data.
Mr. De Learned Advocate appearing for the state fails to produce any document to show that any award was passed subsequently in respect of the lands in question. First up, Mr. De, that is no other document is there.
Yeah, what?
Yes. The hearing.
So there is no other document.
Stop. Heard the learned advocates for the parties. Hearing stands concluded. Judgment stands reserved. Yes.
Specific one for my lord order sheet specific affirmation that the no award was in every time.
Where?
That is the on the same way and the estimate are prepared assuming another which is
Which order? Which order?
what is the order of the
Subsequent 1st of October 2009.
first
No award was passed.
award was not.
Page.
That is page 27.
Page 27.
Yes, page 27. Which portion?
Last
The-
last 8 lines. And that race was required to prepare as the award was not made on the probable date. 8 lines, my lord, from the bottom. As the same way, the estimate was prepared.
Finally, mark the portion.
So, my lord, I may not want to. So, my lord, according to this, there is an award on the court.
But that is one way, but the way the
I know, my lord, only for that reason I
ask your officers to be
it is very difficult.
file
job,
the
my lord.
opposition.
At that time, my lord, if they completed the award and pay the money,
No.
my lord, nothing was there.
Sir, that is one thing. That is one thing. Whatever has been done, whatever has not been done, that is one thing. But filing of these affidavits,
Another
by
thing,
saying
my lord,
one thing,
they are filing one affidavit
and
with
it
the,
must have been said that it is information
Yes,
derived from the records.
only for that.
What records he has consulted?
Only for that reason, my lord, I may not want to go into the merits at that month. As because, my lord, we failed to complete the award, so my lord.
He is talking about the order dated which I shown to your lordship at page
1st of
24.
October.
Yes. That's 1st of October, they are admitting that fresh estimate was not prepared. And so,
Yes, that is what is on record. That is, but the earlier affidavit is damaging.
Yes, my lord, only for that reason. I may
Take
not-
your officers to task, Mr. De. Next.
Item number 85 fixed at 2 p.m. Ram for the petition. The prayer in the writ application is not to permit me to erect boundary wall, my lord, around my own property, my lord. This is the prayer C of the writ application.
Prayer C.
Prayer C, my lord. My lord, there is no dispute with regard to my right to and title over the,
Who is obstructing you?
the private residence client of my learned friend.
Why
my
they
lord.
are obstructing?
Your lordship can see the
Who
affidavit.
are they? They are the adjoining owners.
No, my lord. Yes. Yeah, five affidavit. They have filed their affidavit in opposition, my lord.
What is their stand in the affidavit?
Lordship can see the opposition, my lord.
My lord, may I mention one thing? Copy of the reply has not been served as on date.
I'm giving this right.
Show me from the opposition what is your stand.
My lord,
Have you filed your opposition?
Yes,
my lord, I have filed my opposition, my lord. Copy has been served, my lord. And my lord, this land, my lord, in this land, my lord, there was a Bedi and Kali temple with my lord Radhakrishna temple is lying there, my lord. My lord, what has been done at the instance of the petitioner? The petitioner bought this plot of land by a registered deed, my lord, deed of sale, my lord. And thereafter, my lord, he has come before this court with the plea that I am obstructing to construct the boundary wall. My lord, there is no materials on record to show that he even stocked any sand, my lord, brick.
All right, then I'm recording. You do not have any objection.
No, my lord.
So that he can construct his boundary wall. I can record that. I will
My lord,
construct
kindly
the
consider
boundary wall.
one thing. My lord,
Are you objecting to the construction of the boundary wall?
my lord, I have no objection, but my lord, with
I'm recording that.
144 proceedings is pending, 107 proceedings are pending. This is a civil dispute, my lord. He has come before this court.
I want to know what is the dispute.
The dispute is, my lord, we are the committee who are running, my lord, a Kali temple. It was established in the year 1770.
Kali temple is inside this plot.
Inside this plot, there is a Bedi, my lord, wherein, my lord, thousands of people participate in a mela.
Show me where have you stated this fact in the opposition?
My lord, kindly
Which
consider, my
paragraph?
lord. My lord, kindly consider page 2, my lord. I am starting from page 2, my lord.
Page 2 of the opposition.
Opposition, paragraph 4B, my lord. My lord, that one should approach the writ court.
Paragraph 4,
Paragraph 4, my lord, subclause B.
there is no subclause in,
Page
oh,
2.
this is the reply, sorry.
My lord, that one should reach the writ, my lord, may I read out?
Yes,
That one should approach the writ court with clean hands, but in the instant case, it has been alleged that the
show me
private.
the factual part, don't place
My lord.
that. Adjacent to the disputed land is the Shivkali temple.
My lord, kindly consider, my lord, next page, my lord. That adjacent to the disputed land, there is a Shivkali temple established in 1170 Bongabdo, and in front of the same, in the disputed land, there is a Bedi with Radhakrishna idols, where daily Seva Puja of the goddess Kali and Shiva and Radhakrishna are being held by the inhabitants of local Bakura town and other surrounding areas. On next paragraph, that the writ petitioners, private respondents, along with thousands of local people are involved with the daily Seva Puja. And in course of continuing such Seva Puja on 12 December 2021, the petitioners purchased the same from one of the disciple and recorded their names in the record of right. My lord, next, that after the preparation of record of right in the name of the petitioners to get possession in the land in question, they have approached the police authorities with the false plea that the respondents are obstructing them while making the boundary wall around the land in question, my lord. That the, my lord, next paragraph, that the allegations of the petitioners that the respondents are preventing them from constructing boundary wall is false and concocted, and to get possession of the disputed land in question by obtaining an order of police protection from the honorable court. Well, next, that apart from the Bedi and idols of Radhakrishna in the disputed land in question, the Kali and Shiv Mandir in other part, the local people organize Mela and Puja Bandap upon the land in question each and every year with the due permission of the subdivisional officer Bakura and Bakura
Who
municipal.
are the private respondents? Are they the Shivaites of that?
Sevites of the, my lord, Kali temple and
Lordship, kindly, my lord, go through the
Where have you stated that? They are the Shivaites?
Lord, your lordships kindly consider the photographs, my lord. Annexed to the, my lord, affidavit in opposition, my lord, the with regard, my lord, page.
And which is the property of the petitioner?
My property of the
From the
petition.
photograph at page 17?
My lord, where is the Bedi, my lord? The Bedi in the bottom
Yes.
portion. That is the disputed land in question, my lord.
Bedi is on the disputed land.
My
Your
lord.
lordship, kindly consider, my lord.
No, no, sir. Please answer whether Bedi is on the disputed land, yes or no.
No, my lord, as per my lord, not, my lord, I've been controverted, your lordship can go through the affidavit reply, my lord. Kindly go through.
Resolve that dispute then. Yes.
No, lordship, kindly consider, my lord. Your lordship kindly consider my submission.
Is this Bedi inside or outside the
No,
disputed
my lord,
land?
kindly see, my lord. First of all, my humble submission before your lordship is this, my lord. They have no right.
All right.
Number one. Number two, your lordship kindly consider, my lord, the order passed, my lord, by this honorable court, your lordship kindly see, my lord, what is the contradiction. That's passed on 12 December 2025 by this court, your lordship kindly go through this order, my lord. I'm reading it.
In this matter,
In this matter, my lord. Your
12th of
12th of December 2022, my lord. Passed by
12th of
the Honorable
December. Give me a
Justice Joyce and Gupta, my lord. No civil dispute is there, my lord. There is no dispute. My lord, I want to erect boundary around my own property. So far as my property is concerned, my lord, that the documents that I have annexed in the writ application, I want to protect my own property, my lord. Your lordship kindly consider. And if there is a dispute with regard to my own property, my lord, then my learned friend could have a different case, my lord. But here I have made out a clear case in the writ application annexing those all documents, my lord. Nothing beyond. I am doing nothing beyond that, my lord. And the allegations, my lord, with their stand, my lord, kindly, learned counsel appearing on behalf of the petitioner submits that follows by entering into two deeds purchase. The petitioner has purchased two properties totaling 5 cutters of 2021. After that, the names were duly recorded in the land record. However, when the petitioners went to construct a boundary wall in the said property, the local people, including the present private respondents, stated and initiated them the prepared from the construct in the boundary wall. Reliance is based on the regulation 666 and 669 of the West Bengal Police Regulation Act 1943, and it is submitted that the police guards can deploy to protect the right of the private respondent persons after on a permanent or on temporary basis. All that it's request in the present case is a temporary deployment of police personnel at the place so that the petitioners can construct the boundary wall for that petitioner are ready to pay necessary charges. Reliance is also placed in the decision of the such and such. I'm not much in judgment. Next paragraph. Learned counsel appearing on behalf of the state submit that prayer made in the writ application are not in consonance with the presence made before the police authorities. Learned counsel appearing on behalf of the private respondents first submit that the petitioners and the private respondents are the Sebayets of the temple of Kali and Shiv, which is situated inside the property in question. However, later on, learned counsel for the private respondent submit that actually the Bedi for the temple is inside the state property and the petitioners and the private respondents are not the Sebayets, but they worship in the temple along with the others. The private respondents are not trying to hinder the petitioners from constructing the said boundary wall. Let the private respondents file an affidavit including the basis of the submission made on their behalf, especially the situation on the positions of such and such. An advance copy of the same may be handed over to the learned counsel for the other side. Let this matter come up for further hearing for such and such. Now, I took out after filing the affidavit.
Whether the Bedi is inside the disputed property or not, I am asking
Lordship
you.
kindly consider me, Lord. I'm reading the reply. I controverted.
Yes, what have you said in the reply?
That, your Lordship kindly come to first paragraph 2. I have been copy of the purported affidavit in the opposition appropriate such and such. I'm coming, Lord, paragraph 5. It is relevant, Lord, with reference to a statement contained in the various sub-paragraphs of paragraph 4 of the said affidavit. I deny and dispute each and every statement contained therein.
So you have denied that there is a Bedi in the suit property. Paragraph 5.
This petition is not maintainable in the suppression of material facts, that there is nothing on record to say that the private respondents have obstructed the construction of the activities of subject land. But what is the abnormal to caution the writ petition has been filed?
Don't place the entirety. Place the relevant portion, whether the Bedi is inside the property or not.
Subject property along with the private respondents to the learned advocate claims before the honorable.
Paragraph 5. Straight away come to paragraph 5. So you have denied that.
Yes.
So according to you, Bedi is not inside the
disputed. Stand taken in the affidavit. I mean, your Lordship, police their report that has been filed earlier before this court. This is also on record. And your Lordship can see the report of the BLRO. This has been annexed in the affidavit in the opposition of Lordship. Kindly go through, my lord.
Yes, what does the BLRO say?
I'm coming on basis of the on basis of the affidavit 144 proceedings initiated by me, Milord. I'm coming, Milord. I'm sorry.
Yes, what did the BLRO say?
I'm coming on this, Milord. Milord, also kindly see paragraph 9, page 19. Page 19 of the Milord opposition, their opposition, Milord. Milord, can see.
Yes.
It is addressed to the BLRO by the revenue office, revenue inspector. This is in Bengali script, Milord. After निर्देश अनुसारे 25 में 2022 तारीखे एमओ साजन साज सीआरपीसी পরিপ্রেক্ষিতে বাঁকুড়া মৌজা সাজন সাজ দাগের সরজমিন তদন্তে গিয়েছিলাম। তদন্তকালীন সময়ে উভয় পক্ষ সরজমিনে উপস্থিত ছিলেন। সরজমিনে তদন্ত ক্রিয়া দেখা জানা গেল যে বাঁকুড়া মৌজার উক্ত হাল দাগগুলিতে প্রথম পক্ষ শ্রী বিকাশ কোনার ও শ্রীমতী রমা কোনার এবং উপরের পরিমাণ যথাক্রমে সাচ এন্ড সাচ, যেখানে দ্বিতীয় পক্ষগণ মল্লেশ্বর কালী ইউনিয়ন কমিটি মালিকানা সত্ত্বের কোনো প্রমাণপত্র দেখাতে পারেনি। মিলট, দিস ইজ দ্য রিপোর্ট। অ্যান্ড তদন্তে আরো জানা গেল যে হালনগর সাচ দাগের মৌজা পরিমাণ সাচ
তদন্তকালের সময় আরো জানা গেল। ইয়েস,
তদন্তে এইখানটা
তদন্ত করার সময় আরো জানা গেল যে হাল দাগ সাচ দাগের মোট পরিমাণ যথাক্রমে 7.5 একর, 7.5 একর, অর্থাৎ মোট দাগের মধ্যে প্রথম পক্ষে রেকর্ডভুক্ত জায়গা সহ পুরো জায়গাটির বেশ কিছুটা পরিমাণ কাটা দিয়ে ঘেরা আছে। তৎকালীন সময়ে আরো জানা যায় যে প্রথম পক্ষের জায়গা পূর্ব দিকে একটি বেদি লক্ষ্য করা গেল।
জায়গা
My lord,
পূর্ব দিকে,
my
the
lord,
eastern portion.
kindly consider.
Side of this disputed property.
Lordship
My lord,
kindly consider,
my
my
lord.
lord. Lordship kindly, lordship kindly consider, my lord.
You have placed this report,
My lord, no, this is their stand, my lord. I have not placed, my lord.
not their stand.
What I am telling, my
You
lord.
are disputing.
Your
this.
lordship kindly consider, my
Are
lord.
you disputing
I am
this?
disputing this, my lord. Why, my lord? Lordship, hear me, my lord. That, my lord, what is my prayer? What case I have made out in
Want
the
to you have purchased the
utility
property,
application, my lord.
it has been mutated in
Your
your
lordship,
name, you want to construct
yes,
a boundary.
around my own property, my lord. So, my lord, your lordship kindly consider, my lord. When there is no materials which, my lord, placed by the private respondents, my lord, which do not support their, my lord, locus or their right to create any dispute, my lord. When the title with regard to the land is not disputed and they have taken, my lord, contradictory stand in the affidavit in opposition, my lord, someone claiming something, for your lordship, my lord. First, they have to show before your lordship what is their right over the property to raise this dispute. If they able to show a single document, suppose I have few vacant land and I am for the limited period I am not enjoying. Some outsiders came and started to do few rituals or something. Then I asking myself, right have been created in favor of those all outsiders or miscreants or who want to grab the property.
Followed, yes.
Your lordship kindly consider police
My lord,
report also, my lord.
My lord, may I give a short reply, my lord? My lord, we are the private respondents, my lord. This temple, my lord, has been constructed in the year 1770, of which he was also a part. By some managing someone, my lord, he has bought this property. Now to get the possession, my lord, he has approached the High Court. My lord, I am asking a question to myself. He could have approached the civil court to get possession of the same if he has, my lord, purchased by way of deed, my lord. My lord, the Kali temple along with the Bedi is there, my lord. Mela is being conducted, my lord, each and every year. Now their stand is in that they want police protection to construct the boundary wall, my lord. This is their stand, my lord. And with regard to, my lord, what has been placed by the order dated 12/12/2022 passed by the Honorable Justice Joy Sen Gupta, your lordships kindly consider the next order passed by the Honorable Justice Joy Sen Gupta. He has denied to interfere into the matter, my lord. Kindly consider that order, my lord.
Order dated?
After filing of the affidavit in opposition. Order dated, my lord, after 12/12/2022, the next order. Kindly consider, my lord. That was this, my lord. That was on the
What is the date of the order?
One order is
15/12/2022. 15/12/2022. Kindly consider.
15/12/2022,
my lord.
No order has been passed.
No, my lord, passed, my lord.
15/12, report was kept, police was directed
lord.
to keep a strict
Your
vigil.
lordship,
My lord,
with the report,
my lord, the
police
Honorable
report.
Justice, my lord, did not want to interfere into the matter after passing that order, my lord, in the first instance, my lord. Kindly
All right. Yes. You are for the state.
My lord, this is an application under 226, my lord, for police in action, my lord. At page number 101 is their complaint, my lord.
101.
Page number 101 of the petition, my lord. The relevant portion. 101 continuing to 102. My lord, last 3 lines, my lord, what is their prayer of the petitioner, my lord? এইসব ব্যক্তিগণ জোরপূর্বক আমাদের বাউন্ডারি দেওয়াল নির্মাণ করিতে বাধা প্রদান করে এবং হুমকি দেয় এবং প্রচুর অর্থের ডিমান্ড করে আমাদের কাজ করিতে আমরা সাধারণ মানুষ হয়ে আমাদের জায়গার উপর বাউন্ডারি আমার আবেদন
Yes, they have paid for police protection so that they can construct the boundary wall.
they have not, my lord, may I hand over? My lord,
What is that?
My lord, we have initiated 107, which the petitioner has suppressed. That on the basis of this complaint, we have actually the police authorities has initiated 107 against both the parties. And my lord, at page 7 of the petition, my lord, under the guise of actually, my lord, an application under 226, the petitioner has filed an application for house possession and injunction, my lord, at page 7, my lord, which is specific.
Page 7 of the page 7.
My lord.
Yes.
My lord, paragraph number first 10, my lord. The private respondent and the police authority has failed to protect and secure the lives and property of the petitioner, my lord. First, my lord, they have suppressed about the initiation of 107 proceeding, my lord, and the paragraph number 11 is very much important, which shows their intention, my lord. The petitioner submit that the land in question is their own property and this same is recorded in their names, and the private respondent have acted illegally in order to grab the property of the petitioners without any right, title, interest or whatsoever.
Yes, they have produced the deeds.
My lord, we are not, obviously, we are not here, my lord, to adjudicate the right, title, interest of the property, my lord. My lord, so far as the protection, police protection is concerned, and as it has been specifically fallen from your lordship, the question as to whether there is any baby over the disputed land or not, my lord, in the report I have handed over up, my lord. Second page, my lord, I don't.
In the report, this 107 proceedings.
No, my lord.
No.
The report, my lord.
Oh, yes, report. Second page.
Second page, my lord. Fourth line, fourth paragraph from the bottom, my lord. It is also defined that said Maleshwar Kali Puja temple constructed a baby on the above disputed land, my lord. My lord, this is at all not a case of police inaction, my lord.
All right.
My lord, and only, my lord, I will add one line, my lord. This plot is undemarcated as on date, and secondly, my lord, they have not taken any permission from the concerned municipality to construct the boundary wall, my lord.
But so far as the
No sanction plan can be shown.
my lord, your lords can see, my lord, what is their right?
My lord, they have
Construction of boundary wall sanction plan is necessary.
My lord, they are
So far as the municipal act,
but my lord, they
I'm
are-
asking you.
my
Show
lord,
me the
that is-
provision.
That is not required, but my lord, in
So
this court, they
you are
have
saying
come
they
to
have not
demarcate
obtained
the-
permission. If the law does not require permission, why they will
I take
obtain
back that, but
permission?
my lord, kindly consider they have come to demarcate the land, my lord. It is an undemarcated plot.
That is a different thing. Asim.
They could have approached the civil court, my lord.
My lord, yes, civil dispute, police is nothing to do. Police has nothing to do.
The petitioner has prayed for a direction upon the police authorities to render necessary assistance to the petitioners for construction of boundary wall on the land of the petitioners and to restrain the private respondents from creating any disturbances during the construction work. Paragraph. Petitioners claim to have purchased 2 plots of land measuring about 3 kathas 6 chataks 8 square feet and 1 katha 10 chataks, total measuring about 4 kathas 16 chataks 8 square feet within Mouja, Bankura, jail number 211, dag numbers 6041 and 6042. By virtue of registered deeds of conveyance dated being deed numbers 5735 and 5734 for the year 2021. Petitioner claims to have mutated their names in the revenue records. First up, the petitioner alleges that while the petitioners attempted to construct boundary wall encircling their property, the private respondents created obstruction in the construction work. First up, paragraph. The learned advocate appearing for the petitioner submits that the petitioners are the owners of the property by virtue of purchase through the registered deed of conveyance. Full stop. He further submits that the petitioners are in possession of the said property. Full stop. The learned advocate further submits that construction of boundary wall is necessary for the purpose of protection of the property of the petitioners from encroachment by outsiders. So, paragraph. The learned advocate appearing for the private respondent submits that the petitioners are not in possession of the property in question. He further submits that there is a temple and a bedi on the property in question, and the petitioners are trying to oust the private respondents from possession of the portion of the property. Just a paragraph. The learned advocate appearing for the state submits that pursuant to the complaint made by the petitioner, a spot inquiry was conducted and it was found that Maleshwar Kali Puja committee constructed a bedi on the disputed land. He further submits that a prosecution under section 107 of the Criminal Procedure Code has also been submitted. Heard the learned advocates for the parties and peruse the materials placed. First up, paragraph. The petitioner has produced the registered deed of conveyance in support of his claim that the petitioners are the owners of plot numbers 6041 and 6042 within Mauja, Bankura. Paragraph. The private respondents in their affidavit in opposition has stated that adjacent to the disputed land, there is a Shiv Kali temple, and in front of the same, there is a bedi with Radha Krishna idols where daily Shiva Puja of goddess Kali, Shiva and Radha Krishna are being performed by the inhabitants of local Bankura town and other surrounding areas. First up, the said affidavit, an inspection report of the revenue inspector dated 25th of May 2022 has been annexed. It has been stated in the said report that upon inquiry, it was seen that in the eastern portion of the disputed plot, there is a bedi. First up, from the report of the sub-inspector of police, Bankura police station, it appears that upon inquiry, it was learned that a dispute arose between the petitioner and the private respondents with regard to possession. Full stop. paragraph. Before allowing a party to construct a boundary wall, the boundary line of the property is to be ascertained. First up, the police authority is not vested with the power to decide on the issue of boundary line of an immovable property. First up, it further appears that there is a Vedi within the plot in question. First up, the private parties have now. It further appears that there is a dispute with regard to possession of the property, possession of the immovable property between the private parties. First up, such a dispute cannot be decided either by the police authorities or by this court under Article 226 of the Constitution of India. First up, in view thereof, this court is not inclined to grant any relief in favor of the petitioner, granting police protection for construction of the boundary wall. It will be open to the petitioner to approach the proper forum for appropriate reliefs in accordance with law.
But, my lord, your lordship consider
With
one
the
thing, my lord. Your lordship, my lord.
observations
My lord,
and directions, the writ petition stands disposed of, no cost, urgent photostat certified
lordship,
copy.
can you consider one thing, my lord? My lord, that, my lord, if, my lord, lordship already, my lord, decided disputed, my lord, this is a disputed, my lord. I am thinking one
Yes,
thing.
yes.
My lord, someone coming.
Resolve that dispute. Yes, call the next matter.
89.
Yes. Yes, you are referring to Rule 54.
My lord. I have shown my line to A, section 9, 2A, to section 2A. Then 54 of the resident title regarding the, that is regarding so motor reform.
Your one submission is that the appellate authority could not have exercised the power of revision.
My lord.
It has to be some superior authority.
My lord, against the appellate order, my lord. Superior to the appellate authority.
Yes. Any authority superior to the appellate authority.
My lord.
So in support of that, you are placing section 9.
9, 2A and 2B of Act. 2A, my lord. Any error member of the force agreed by an order passed in appeal under the May within a period of 6 months from the date to which the order is communicated to him. But revision or review, my lord, comes only against the appeal was decided. Next, B also, my lord.
Yes.
The authority has been prescribed about this.
So this is the power of revision.
Revision, my lord.
So no power of review.
No power of review in the rule. No power. Nine 2B, my 2B, my lord, my lord. The authority has been prescribed for the purpose of action on a revision petition preferred by agreed enrollment force or suo motu. Whatever may be, that may be against the appellate order.
So this revision can be suo motu or on an application.
On application. Against the appellate order.
But there is no power of review.
No power of review. My lord, that is.
Yes. Is there any power of review? Then it has to go on that.
Let me.
Show me that there is a power of review. Sir, give him your book.
My lord, kindly comes to Rule 54.
No, here the facts were the disciplinary authority imposed some punishment.
A few points are there. Let me make it short. First, admittedly, disciplinary proceeding was initiated. He got punishment. Commandant issued the final order. First point. Secondly, After seeing that order, as per Rule 54, kindly see the Rule 54 once.
Yes.
I'm placing, my lord. First, any authority superior to the authority making the order. Superior, here this line, my lord. Superior to the authority making the order. Order means the original order. On his own motion or otherwise. Here, my lord, on his own motion, the authority took up the case and issued a show cause notice. Now, my lord, kindly sees the proviso part. One proviso. Provided that no order imposing or enhancing any penalty shall be made by any revisioning authority unless the enrolled member of the force concerned has been given a reasonable opportunity of making a representation against the penalty proposed, where it is proposed to impose any other penalty and such and such. Here, show cause notice is issued. He replied to the show cause notice. Subsequently, my lord, kindly comes to 54.2. 54.2 says, the provision of Rule 52 relating to appeal shall apply so far as may be such order in the revision. Here, my lord, if the penalty is enhanced under Rule 54, then the 52 will be applicable. He has authority to prefer an appeal against such order, which he has done. He has preferred an appeal against the order passed in the... And my lord, in appellate authority...
Sir, please one thing. The disciplinary authority imposed a punishment. Now, against that, he has not preferred any appeal. No, he has preferred an appeal, but prior to that, the appellate authority, or if, on your words, an authority
superior to
the disciplinary authority issued a show cause notice for suo motu review, not revision. Show me the power of review under the statute.
Kindly. But kindly, it comes to page number 49, that is show cause notice.
Page number?
49.
No, from the rules, show me that there is a provision in the rules for suo motu review.
Suo motu revision, my lord.
Well, come to the show cause notice. It does not say revision.
49.
Page?
Page 49, show cause notice.
Show cause notice.
Page 49. Kindly comes to last paragraph, 4. Page 50.
Yes.
Hence, in the exercise of power conferred on me under Rule 54(1)(b) of CISF rules, I, undersigned, propose the enhance of the above penalty to the extent of removal of service from such and such. Solapur is hereby given opportunity to submit representation in writing, if so desired, within 15 days of receipt of show cause notice, failing which it will presume that he has nothing to submit against the proposal of expedition will be taken against him.
So this is revision, not review.
No, my lord, this is a revision. As per rule, only point he has, my lord, that is authority did not have any power.
Kindly come to page 84. The order passed.
84.
Yes.
Order in suo motu review.
Review, not revision.
My lord, nomenclature may be different, my lord.
All right. Yes, revision. Show me the power under the statute of revision.
My lord, kindly see the 54.
Rule not. Section. Show me the power of revision. Statute gives the substantive provision. That is the rules. Show me the power of revision from the statute. Act, not the rules. Rules is procedures.
Yes, my lord.
So show me the power of revision.
9.
Yes, 9 place 9.
Any enrolled officer of the force agreed by an order under section 8.
So an order under section 8 was passed. Yes, may.
Within 30 days from the date on which the order is communicated to him, prefer an appeal against the order of such authority as may be prescribed, and subject to the provision of subsection 2A, subsection 2B, subsection 3 of the decision of the said authority, therein shall be final. Provided that prescribed. My lord,
so
there are 2 points.
So now against 8 there is a provision of appeal. Now there is proviso is time limit. Let us skip over that. Next is in disposing shall follow the procedure. Next.
The authority to be
next 2A.
2A.
Yes.
Any enrolled member of the force agreed by an order passed in appeal under subsection 1 may, within a period of 6 months from the date of which the order is communicated to him, prefer a revision petition.
Yes.
Yes, my lord. There are 2 points, my lord. 54, there is 2 parts. In 54,
50, kindly, first the statute gives the power.
my lord,
First
there-
appeal, then revision.
revision.
So in the rules, procedures are prescribed, nothing more than that. That does not give you the power
No, ma'am.
of revision. So here revision is against the order of the appellate authority, cannot be the order of the
My lord.
original authority.
My lord.
My lord,
Show me from the statute, section
my
9.
lord, there are 2 parts, my lord. Decision making, there are 2 parts. First part, first order of the authority,
Yes,
appeal,
yes.
then revision.
Then revision.
Then revision. The
Yes.
normal course.
Here the appeal was not preferred.
This is normal course. This is normal course. Another thing is that if the authority finds the order of punishment was much lesser, under Rule 54, he has authority, he has power to issue show cause.
Show me from the statute first. 54 is the procedure. 54 is the procedure. Power has to be derived from the statute. Show me the power of revision directly against the order of the disciplinary authority.
But I need just one more day, man, in that case. Man, kindly consider, man, kindly consider, kindly consider, kindly consider. But again, I am submitting, let my submission be recorded, man. There are 2 parts, man, in 54.
So according to you, revision against an order of the disciplinary authority is permissible in view of Rule 54.
Let me place, man, let me place my case.
Yes.
First, the order was issued, disciplinary authority. Subsequently, under Rule 54, show cause notice was issued. He got a chance, he replied to the same, and in 54, an order was passed. Order was passed for removal of service. He preferred appeal as per Rule 52. Minor 54.2, kindly see. 54.2. The provision of Rule 52 relating to appeal shall apply so far as may be such order in the revision. If any order is passed for enhancement under Rule 54, then he has authority, he has chance to prefer an appeal under Rule 52. 54.2. The provision of Rule 52 relating to appeal shall apply so far as may be to such order in revisions. And if any order of enhancement or is made, then he has chance to assign the same.
This is the procedure, sir, not the provision. Appeal is a statutory provision. If the statute does not prescribe, how can you say the rules give a right of appeal?
My lord, for a moment, come to 9.3, my lord. 9.3.
What I am submitting, my lord, these particular rules gives 2 options. There are 2 ways. First, order, appeal, then revision. Second, under Rule 54, the authority has power to issue a show cause notice for enhancement set aside either suo motu or in application, which my friend is submitting is the best case. And after appeal, he is coming to revision. But in this case, Rule 54 was invoked by the higher authority. By invoking the same, the punishment was given. And he preferred appeal against the same, my lord. He preferred appeal against the same. And page 1110, in the appellate authority confirmed the order passed through by way of this, the removal of service. This is my case, my lord.
My lord, come to section 9.3, my lord.
Anything more?
My lord, come to section 9.3 for.
Why did you prefer an appeal against the order of revision?
My lord?
Why did you prefer an appeal against the order of revision?
My lord, come to section 9.3 for a moment.
9.3.
9.3.
As per 52.
Act 9.3.
Yes.
The central government may call for and examine the record of any procedure.
Yes.
My power is vested with the central government. How can he call for the record?
No.
He is not the central government. He cannot call for the record, cannot review.
Page 88, my lord, is the appeal.
He can review it.
No. Why did you prefer an appeal against
With the hope of getting justice from superior authority, he has preferred this appeal. That is one aspect. No, my lord. Regarding the proceedings, my lord, no presenting officer was appointed. May I please judge?
The petitioner has challenged the final order passed by the disciplinary authority comma, the order passed, no, the order passed on a suo motu review and the order passed by the appellate authority against the order passed on suo motu review in this writ petition. Full stop. The petitioner now, while the petitioner was posted at CISF Unit Eastern Coalfield Limited, a memorandum of charge dated November 3, 2007 was issued alleging that the petitioner has failed to prevent the theft of diesel from a crane. Full stop. The inquiry officer, after completing the inquiry, submitted the report. Full stop. The disciplinary authority passed an order dated June 23. No. Where is the order of the disciplinary authority?
41.
41.
Start from page 41.
The disciplinary authority passed the final order on 29th of April 2008. Imposing the a punishment that the pay of the petitioner be reduced by 4 stages from rupees 3,800 to rupees 3,500 in the time scale of pay for a period of 2 years. So it was further directed that the petitioner will not earn increments of pay during the period of reduction, and that on expiry of that period, the reduction will have the effect of postponing his future increments of pay. The petitioner claims to have preferred an appeal against the final order of the disciplinary authority dated April 29, 2008.
Prior to appeal, show cause notice was issued. Prior to preferring appeal, show cause notice was issued.
However, in the meantime, a show cause notice dated June 23, 2008 was issued by, who is the authority?
By my lord.
Appellate Authority, Deputy Inspector General.
Yes.
Was issued by the
Deputy Inspector General, Appellate Authority.
Deputy Inspector General, being the which respondent?
Fourth.
Being the 4th respondent, asking the calling upon the petitioner to show cause as to why the penalty inflicted by the disciplinary authority in his final order of punishment should not be enhanced. Petitioner claims to have replied against the said show cause notice. The fourth respondent passed an order on 7th of August 2008, which is stated to be an order on suo motu review. Petitioner filed an appeal against the order dated August 7, 2008, which was dismissed by the which authority?
Inspector General.
Which was dismissed by the Inspector General, being the
Respondent number.
being the third respondent by an order dated December 26, 2008. The paragraph. The learned advocate appearing for the petitioner submits that the fourth respondent is the submits that as per the rules, as per the Central Industrial Security Force Rules, 2001, for short the 2001 rules, the Deputy Inspector General, being the fourth respondent, is the appellate authority. First up, he submits that as per Section 9 of the Central Industrial Security Force Act, 1968 for short, the 1968 Act, a revision lies only against an order passed in an appeal under Section 9 of the said Act. First up, he submits that the appellate authority, he submits that the fourth respondent, being the appellate authority, is not vested with the power to exercise the power of is not vested with the power to revise an order passed by the disciplinary authority. First up, paragraph. The learned advocate appearing for the respondent submits that the fourth respondent is an officer superior in rank than the disciplinary authority. First up, he submits that Rule 54 of the 2001 rules empowers an authority superior to the authority passing the final order of punishment to revise such an order. First up, he further submits by referring to subsection 2 of subrule 2 of Rule 54, that by referring to subrule 2 of Rule 54, he submits that the said order passed in revision is appellable in view of Rule 52 of the 2001 rules. First up, heard the learned advocates for the parties and peruse the materials placed. First up. The petitioner the disciplinary authority is which respondent? No.
Which respondent?
Commandant is the disciplinary respondent number 5. Yeah, the disciplinary authority na kore. The commandant's Central Industrial Security Force, being the 5th respondent, is the disciplinary authority of the petitioner. Such disciplinary authority passed the final order of punishment. It appears from the record that the 4th respondent, who is the appellate authority as per the 2001 rules, issued a show cause notice and passed an order on suo motu review dated August 7, 2008. The learned advocate appearing for the respondent would submit that though the 4th respondent exercised the powers of revision, but the caption of such order was inadvertently mentioned as suo motu review instead of suo motu revision. Paragraph. In order to decide whether the 4th respondent, who is the appellate authority, could exercise the power of revision, the certain provisions of the 1968 Act and the 2001 rules are to be considered. First up, Bole set out section 9 or rule 54 or rule 52. এই তিনটে সেট আউট করবেন, ঠিক আছে? রুল 52 এদিকে হিন্দি আছে, বাঁদিকে বাংলা মানে ইংলিশ আছে। হ্যাঁ, ইংলিশটা থেকে সেট আউট করবেন। তারপরে লিখুন section 9 within bracket 1 states that any enrolled member of the force aggrieved by an order made under section 8 may prefer an appeal against such order to such authority as may be prescribed and subject to the provisions of subsection 2A, subsection 2B and section 3. না কি বললাম? Prefer an appeal against the order to such authority as may be prescribed. Full stop. The decision of such authority shall be final, subject to the provisions of subsection 2A, subsection 2B and section 3. First up. Subsection 2A of section 9 gives the right to an enrolled member of the force aggrieved by an order passed in appeal under subsection 1 of section 9 to prefer a revision petition against the order to such authority as may be prescribed. And in disposing of the revision petition, the said authority shall follow such procedure as may be prescribed. Subsection 3 empowers the central government to call for and examine the record of any proceeding under section 8, subsection 2, subsection 2A or subsection 2B of section 9 and make such inquiry or cause such inquiry to be made and subject to the provisions of the Act may pass such order thereon as it thinks fit. Upon reading section 9 as a whole, this court is of the considered view that the power of revision can be exercised only now the power of revision by an authority prescribed under the rules can be exercised against an order passed by the appellate authority, either suo motu or on the basis of an application made by an aggrieved party. The rules for preferring the revision application has been specifically laid down in Rule 54 of the 2001 rules. First up, it is well settled that the statute can only vest the right of appeal, revision or review, and the rules can prescribe the manner in which such right can be exercised. This court is therefore not inclined to accept the submission of the learned advocate for the respondent that Rule 54 of the 2001 rules gives power to the appellate authority to exercise the power of revision. First up, upon reading section 9 and Rule 54, section 9 of the 1968 Act and Rule 54 of the 2001 rules, this court is of the view that the power of revision under section 9 within bracket 2A, comma 2B can be exercised only by an authority as prescribed in the rules, and such authority has to be superior in rank to that of the appellate authority. First up, in view thereof, this court holds that the Deputy Inspector General, being the fourth respondent, could not have exercised the power of revision / review, could not have exercised the suo motu power of review / revision. First up, the order dated 7th of August 2008, passed by the order of the fourth respondent dated August 7, 2008 is, therefore, without jurisdiction, and the same is liable to be set aside and quashed. First up, accordingly, the said order is set aside and quashed. First up, since the order dated August 7, 2008 has been set aside, the order passed on an appeal against such order is also without jurisdiction, and the same, the order passed, the order dated December 26, 2008, passed by the third respondent on an appeal from an order dated August 7, 2008 are also set aside. First up, paragraph. Your appeal is pending.
Appeal is pending till.
First up, since the petitioner has preferred an appeal against the order of the final order of the fifth respondent dated April 29, 2008, the appellate authority is directed to dispose of the same as expeditiously as possible, but preferably within a period of
8 weeks. 8 weeks.
8 weeks.
In any case, I have to prefer
Within a period of 8 weeks, a server copy of this order. First up, are only for the purpose of supporting the ultimate conclusion in this writ petition, and the same shall not prejudice the parties in the appeal which is pending before the appellate authority against the final order of punishment dated April যেটা কত April? April 29, 2000.
Not praying for stay of the operation.
কি বললাম? With the above observations and directions, the writ petition stands allowed to stop. After this order is dictated, the learned advocate appearing for the respondent prays for stay of the order to stop. Are you opposing the prayer for stay?
My lord.
The prayer for stay is opposed by the learned advocate for the petitioner. To stop, the prayer for stay is considered and rejected.
Good.
Keep this book because it will be this. Yes. Thank you. Yes, call the next matter.
90. My lord, I appear on behalf of the petitioner. This is
You are for the CSC,
this is against
order of the ombudsman.
no, my lord, this is in respect of the order challenging the order of appellate authority. This has come up, Mr. Rice.
Provisional assessment.
Appellate authority's order, my lord. Provisional
Against provisional assessment.
My lord, I will only request if my lord may give us some more time for till next week. My lord, very ugly facts, my lord. Mr. Rai is leading me, my lord. Let us come back next week.
Mr. Rai will not come.
No, he'll come. My lord, my lord, kindly give us till next Wednesday, my lord, give us some time, my lord.
Till next Wednesday, why?
My lord,
Mr. Rai will not be available.
my lord, he will be available, but we have to sit with him. I will be very candid, my lord.
You will have to?
We have to sit with him, my lord.
All right. As paid for by Mr. Mukherjee, learned advocate for the petitioner, hearing of the matter stands adjourned for the day.
91. সোমবার থাকবে তো? সোমবার থাকবে?
একজন হলো আজকে।
আচ্ছা, সোমবার থাকবে?
এই তো 3:30 আছে তো।
হুম।
3:30 আছে না?
হ্যাঁ? মানে give us time till Wednesday. কি আবার হবে? বুধবার দিন অবধি হয়েছে। Let it be till Wednesday, man.
আচ্ছা, কি বলে as paid for list this matter?
আমারটা দিন
পরের বৃহস্পতিবার করবে। নেক্সট থার্সডে করে দিন।
এই নামটা দিয়ে দিব, নালে পয়সা দেবে না কেন? I am grateful, man. এটা নেই। WBSC